Hello dear friends, welcome back in our YouTube channel Induslex. Today we are going to understand how to defend ourselves in a criminal prosecution. Dear friend, criminal law comes in motion from registration of an FIR, First Information Report. What is First Information Report? It is an information of cognizable offense. And what is cognizable offense? That the cognizable offense are those offenses in which police may arrest without a warrant. So if a FIR is registered, what remedy we have at the first instance? The first remedy lie in the judicature of High Court by way of criminal writ, that you can challenge this FIR on two major grounds. First ground is that after bare perusal of the contents of the FIR, no offense is made out. Here, the no offense is made out meaning is that the contents of FIR is not disclosing any commission of offense enumerated under the law. And second one is that this registration of FIR is due to malified intention and it is a malicious prosecution. At this juncture, friend, we see that an FIR under POCSO Act is lodged against the Shankaracharya. What he did, he applied for the bail, anticipatory bail in the session court. What is the distinction between anticipatory bail and bail we will discuss later. But when a person is in judicial custody or in common parlance in jail, he apply for bail. But if he is not in jail and police is trying to arrest him, in these cases, person may apply for anticipatory bail, that in the event of arrest, police may, after getting the bail bonds, release that person at that time instantly. So anticipatory bail and bail is at different footing. But when we challenge the FIR, it is for the quashing of first information report, that no case can be prosecuted against the person in respect to that contents which not disclosing the FIR, disclosing the offense, or it is due to malicious prosecution and abuse of the process of law. In anticipatory bail, we apply for the anticipatory bail that in the event of arrest, police may release that person. In the Shankaracharya case, what happened is, there is a serious allegation and matter is registered under POCSO Act. Then he first directly went to the session court and applied for the anticipatory bail, and session court didn't grant him the anticipatory bail, and then he challenging that order in the Hon'ble High Court, and that order is reserved and interim protection is granted to the Shankaracharya. But what mistake is done at that instance is that FIR, as prima facie evident, is a malicious prosecution. That is, there is a tussle of war between the government and the Shankaracharya, and that led to that FIR, and it is a valid ground to claim that the FIR is a malicious prosecution. We don't know what would be the result, whether the FIR is going to be quashed or not, whether High Court is or will grant him something in favor of the Shankaracharya at this stage. But if he failed in the High Court, he may again challenge the order of the Hon'ble High Court refusing the quashment of the first information report in the Hon'ble Supreme Court. So a mistake is done on his part or on the or there may be some other strategy, but in my understanding it would be better for him to challenge the FIR at the initial stage. So whenever an FIR is lodged against any person, it is very important, if there is a chance, to get quash or to get stay on the first information report, always try to file criminal writ petition to quash that FIR. And when you come before the Hon'ble High Court for quashment of the first information report, it may be possible that the High Court grant interim relief in the favor of petitioner, and after that some time may be fixed for counter and rejoinder for reply may be filed by the state government or by the informant, and in meanwhile that the police or investigating officer may file charge sheet in the court below. In this scenario, you again have to challenge the charge sheet also, that look, the entire prosecution has no evidence against me, and on the basis of this, that there is no evidence, there is no disclosure of offense, or there is no legal admissible evidence brought on record by way of case diary, you can challenge it. And if you lost all these two remedies, that challenging the FIR or challenging the charge sheet, then you may approach to the competent court for the anticipatory bail. And if you failed in getting the anticipatory bail in the session court, then you must apply and challenge that order of refusal of anticipatory bail into the High Court. And if you failed in the High Court, and if you can afford, then you must try your luck in the Honorable Supreme Court. And if you have no remedy, if you got no relief from the court, even in the writ jurisdiction or in the anticipatory bail, then you may surrender before the competent court on the advice of your counsel. So whenever the FIR is lodged, you first have to prepare to file a criminal writ petition. And if it is a charge sheet stage and lower court has taken cognizance on your charge sheet, then you must challenge the summoning order, entire proceeding, that charge sheet and FIR. Then after some time it happened that when you approach to the High Court for challenging the charge sheet, the Honorable High Court may direct you for filing the discharge application before the trial court. And on that direction, if you move the discharge application before the trial court, it may be possible that the trial court will find that there is no material to prosecute you or to commence the trial, as it happens in the Delhi liquor case, or we can say in the Arvind Kejriwal case, where the Arvind Kejriwal and his associate is discharged from the case. After the stage of discharge, when you file your discharge application, then the trial, after framing of the charge, then the trial will commence. Before this stage, that before the framing of charge, you have ample remedy if you are not arrested on the spot. That you have a writ jurisdiction, you have the quashment of entire proceeding under inherent jurisdiction of High Court. You can move a discharge application by taking a suitable direction from the High Court, and then you have anticipatory bail jurisdiction, and after that you will have to be surrender before the lower court if you not able to get or you not succeed in getting any relief from the courts concerned. Thank you.